How are you, Representative Hayden?
I'm doing fine, sir.
Good.
Mr. Chairman, members, I believe this is 872, and this deals with child support. Basically, the present law covers reasonable child care costs that are incurred by a party either due to employment or job search. And what this bill would do, it would expand it to include job training or obtaining an education. And this is through some amendments on the House side, one in committee and one on the floor. It made it to the discretion of the court to where the costs, long as they wouldn't unreasonably burden the parent that was paying the support.
Okay. I do not see any cards except for those in opposition, and I have two of those. Timothy J. Patrick would like to speak, and also have Ms. Angelo A. Corsoni. If you would come to the table, sir.
Yes, sir. How are you, Senator Nevins?
Good morning, sir. Welcome to Judiciary A.
It's been a while since I've been here, hasn't it, Mr. Murray? Let me introduce myself to y'all. I'm coming here. It's on a child support bill. I've been married 42 years this year in August, okay? And I've never been divorced. I've never had children out of wedlock. It says on my card that I'm here for my 11-year-old grandson, because I see the way the marriage laws and the divorce laws and the custody laws and the child support laws have gone on in this state forever. And I'm concerned about him. I'm concerned about having to buy him a gift certificate of vasectomy instead of a car when he graduates from high school. And that is a serious statement. And I'm here because I've studied a lot of these laws over the years. I've served on some committees with other attorneys and judges, and I see a lot wrong with this bill. I'm going to begin this way. We went to the income shares child support guidelines to be more fair. That was the original intent for the reason for going to income shares. And I'm going to ask them to pass you this out. This isn't everything that I'm saying. It's just reference material for you. Got one for each of you. In the basic principles, it says, while the legislature acknowledges that the expenditures of two household divorced, separated, or non-formed parent families are different from intact family households, it is very important that the children of the state not be forced to live in poverty because of family disruption, and that they be afforded the same opportunities available to children in intact families consisting of parents with similar financial means to those of their own parents. Nowhere in there does it say mom or dad has to live the same way. Nowhere in there does it say we're doing this now because we're going to want a college education later on and somebody else has to pay for it or pay for the daycare for it. This is directed at the children, not at the parents of the children. That's number one. Number two, in this bill, tell I haven't done this in a while, I'm a little nervous. I usually wasn't nervous. In this bill, oh, there I am. In this bill, in the introduction, and I realize that's not part of the bill, but in the introduction, it says to provide for related matters. And that indicates legislative intent. That means a judge can look at this, or an attorney can bring this up to a judge and say there's a legislative intent to pay for more than child care. That's number two. Number three, there's no related matters or definitions for related matters in there. And here is some of the big points that I want to make. Okay? We already have provisions in the law to handle this matter. You can give a further visitation to the other parent, and he can watch the child. You don't have to charge him for daycare or charge him for child care. And in fact, that's already in the law, which is Article 112. I'm sorry, not Article 112. Article, on page 7, you've got Article 233, duty to receive in whom in lieu of alimony payments, and Article 234, parental choice to receive child in whom in lieu of alimony payments. Those are the two things that should take place before any monetary amount is given to someone in addition to that. What this bill is attempting to do is to circumvent the alimony laws that are presently on the book. That's why I'm calling it the Backdoor Alimony Act. There is a manner in which someone can get this, and it is very clear in, in the alimony law that's already on the books. That's on pages 5 and 6, Article 112, determination of final periodic support. Number 4 on page 5 is the effect of custody of children upon a party's earning capacity. Number 5 is the time necessary for the claimant to acquire appropriate education, training, or employment. And number 7 says the duration of the marriage, which this bill doesn't even allow for. I mean, the Backdoor Alimony Act that we're trying to have passed here does not even take this into consideration of how long they've been married. Another thing that this could be applied to is an unwed mother who may have had 4 children with 3 different fathers. But one of the fathers that she had the last child with makes a better income than the other 2. So now she decides, without ever having been married to him, to take him to court to get this additional amount so that she can go to school. In other words, he's going to be paying additional monies for child support for the other 2 fathers. That is not fundamental fairness that is deserved in the law. That is not fundamental fairness as described by the Supreme Court in a 1934 ruling on due process of law. And it is not due process of law. What you're going to do is you're going to make this below bill, this little law, this little change in the language, come in to head-to-head conflict with other laws that are on the books, particularly the preemption law for alimony. This is a form of alimony. We're trying to put it in the child support law improperly. Okay, we're trying to put it there so that unwed mothers can have it. Okay, also. But this should be covered in the alimony law. It should be covered by the peremptory statutes in the alimony law, which is 3 years. If you pass this, someone can come back 8, 9, 10 years from now who has smaller children, say that she wants to go back to school, drag her former husband, who may be married with another family already, back into court to have him pay for the additional child cost that she's going to incur due to going back to school. People should not be able to be pulled back into court 8, 10 years after divorce. That is just going to enrich attorneys like Senator Murray. You're the only one that know well here, so I picked on you. All right. Boy, Senator Nevers makes a good chairman. He doesn't even laugh, man. He doesn't crack a smile. That's so many other things I had to say about it. And what would it take to remove this? Suppose, okay, they go to school for 2, 3 years, drop out, don't complete the course, don't get what they say they went there for. Okay, what would it take to remove this? Now an individual has to go bring them back to court. $1,500, $2,000, $2,500, $3,000 for attorney's fees to go back to court. They have this removed, or he's got to continue to pay it because it's not under alimony, it's under child support. And they're going to come after him, and they can make him a felon for it because we have a felony law here. This is a serious matter. It should not be taken lightly. And the other thing is, if I'm an individual, and by the way, my son is a domiciliary parent. I didn't tell you that at the beginning. My son is a domiciliary parent of my 11-year-old grandson. So he could use this bill for child care if it passed. And I can tell you, if he was here, he'd tell you he don't want it. He has a 50-50 shared custody agreement. He is a domiciliary parent. The mother of my grandson, after the divorce, after a year or two, went back to school. She got a degree. She got a better job. How did she do that? 50-50 shared parenting. She had the time to do it. They worked together on her schedule. That's how they did it. And when they first got divorced, it was extremely contentious. It was not a happy divorce or a happy custody battle. That much I can tell you. Now, the other thing is, if I'm a guy who's going to pay for this, then I insist, and you need to make some kind of provision, that I can look at your academic records. I'm paying child care because you're going to school. I want to see your academic records. I want to see your attendance records. I want to see that if when I'm paying for additional child care, that you are actually going to school and that you are attending. You could go someplace else. I wouldn't know. I would have no way of knowing. The court would have no way of knowing. I'm sorry to get so passionate about it, but I mean, I just see a lot of the unfairness in the law. This is already covered in the law. You already have alimony. You have other legal instruments in the law already that can take care of this. You can give additional visitation to the other parent. But you see, if we give additional visitation to the other parent, what does that do? It decreases the child support. So what this bill is about is not helping children. This bill is all about money. Now, if I had to guess, and I don't mean to insult the representative of this, it's just that I'm going to give you my experience with a similar bill. Senator Murray wouldn't even remember it because it didn't make it over here. There was a representative a few years back that wanted to increase the child support age to 25 through college. I came out with others to fight that bill. Come to find out, the representative's sister was receiving almost $7,000 a month from her ex-doctor husband for child support. And the child was getting ready to graduate from high school. She was going to take it. She was going to take a hit for $7,000 a month. And I guess when you're used to living on $94,000 a year, you want to keep living on $94,000 a year. But anyway, gentlemen, that's all I have to say for now. I take that back. Another law that he's going to usurp and go around with this is the factors in determining a child's best interest. Okay? How is he going to do that? Well, under ordinary circumstances today, if somebody's going to go to school at night till 9, 10 o'clock at night, okay, or on Saturdays, and not have the children with them, that presents a change in circumstances. I think you can make that stick as a change in circumstances to change the custody arrangement. And if you go to the factors in determining the child's best interest on page 7, I think 134(2), 4, and 5, and 12 would cover that to give a good challenge on changing the circumstances. Well, that's about that's about all I have to say for now.
Thank you,
I just
sir.
want to tell y'all, I'm still just a poor, stupid Cajun boy, with an Irish license plate. But to me, this bill makes no sense at all. To me, this bill is an unjust bill and should not see the light of day on the Senate floor. That's all I have. Thank you for your time, sir.
Thank you, sir, for your testimony. Sir, identify yourself for the record, please.
Thank you, Mr. Chairman. My name is Angelo Corsione. I'm here on behalf of myself and my 2 daughters. They're 11 and 13. I, like Mr. Patrick's son, am the domiciliary parent, and I'm here because I don't want this to go into effect for the simple fact that while, yes, if it did go into effect, it would benefit me if I chose to go to law school, do whatever, but it may detrimentally affect my daughters in the long run. Because as we know, our judicial courts and our laws are becoming more and more consistently applied without thought to gender. So that could mean that my daughters could either benefit from this or alternatively themselves be paying this in the future. That being said, I want to address some of the issues that Mr. Patrick raised. One of them is regarding the spousal support. This is definitely what they're trying to implement here in House Bill 872 is definitely covered and considered within our spousal and alimony laws. What I feel that House Bill 872 is attempting to do is take a collateral attack on it. And if a parent is precluded from obtaining support, a spousal support or alimony because they're at fault in the marriage, no problem, because you can just come under this statute and merely seek that enhancement, for extraordinary expenses for the child to go to school and totally bypass, what is to be considered in our alimony and support laws. Not only also, as Mr. Patrick addressed, the fact that within those laws, we have time frames and time limits that are considered, by our courts. Within House Bill 872, there is nothing that says that, the parent only gets this extraordinary expense for a certain period of time. They could very well end up becoming a career student. I mean, they could get an additional bachelor's degree because the bachelor's degree that they gotten just for posterity's sake, let's say basket weaving isn't giving them a job. So now I have to seek another degree. Well, now that I've got that degree, let me continue on and get a PhD, master's. It can be, indefinite throughout time until, children are 18 and off to college. That's a huge problem in my eyes. The other thing that I want to address before the Senate is that this matter has previously been before appellate courts. I did an exhaustive search through Lexis, and I was surprised, but there is a paucity of case law in this. And I was only able to find one, and that was Hamilton versus Hamilton, where our Fourth Circuit considered this. And they came back and resoundingly said, no, that was not the legislature intent to, provide child care for a parent seeking to go to a school. It was only intended for that extraordinary expense to be provided if the parent was searching for a job or currently working. The other thing is, when you look on page 1 of House Bill 872, lines 19 and 20, it reads, and it's B, when a parent is unable to maintain or secure adequate employment and income to provide for themselves and the minor child, and where the inclusion of the costs do not unreasonably burden the parent paying child support. This is really troublesome, because if you look at the way our statutes are currently, that's one of the issues that when custody is given by the courts to one parent or the other to be domiciliary, that's already considered the ability of the parent to actually provide for food, health care, shelter for the child and other expenses. That's already been considered. If a parent can't, find a job, cannot sit up there and provide for the child, it's kind of circumventing that. It's not kind of, it is circumventing that by allowing them to come back and say, well, I'm poor, I'm destitute, I need to, go back to school, instead of, going back to court and maybe properly seeking, a change and allowing the court to apply a proper change of custody. They're saying we want the non-domiciliary parent to actually pay for child care and pay an additional amount in child support through an extraordinary expense for me to go get an education. So once again, you're circumventing the law. Now, Mr. Patrick brought up a very salient point. One of those is, what do unwed mothers do? Because they're not afforded the opportunity to go before the courts and say, I want alimony, I want, spousal support. Well, that's already being taken care of through the Department of Social Services through the Child Care Assistance Program. They have a program in place where if a parent wants to go to school, they will subsidize some of the cost for them to be able to go to school. So that's already in place. The non-custodial parent or the non-domiciliary parent, if he has not married the mother of the child, should not be cast with that burden when that's already available. And the bill is inequitable in conduct and support. There is nothing within House Bill 872 that spells out what type of school that one would need to go to. Do they want to go to court reporting school? Do they want to get a bachelor's? I mean, there is nothing in there. They just say we want to go to a trade school. There's schools popping up all over the place that don't even provide accreditation that can be transferred to our regular universities. So that's another huge defect I see in the bill. And it also, nowhere does it state how we're supposed to show and that doing this, providing this extraordinary expense is going to benefit the child or the children. I see House Bill 872 as double dipping because let's say that a parent is already, a domiciliary parent is already obtaining spousal support, alimony. They can now add another extraordinary expense to the child support obligation by, saying, oh, well, I'm going to school. The other huge problem that I have with this is that you have a parent that may, throughout the process of separation or divorce, they may have at that time, like in my case, when my ex-wife and I separated, we agreed that between ourselves to reduce the cost of litigation at the time, that look, I'm going to help you with the children, and I said that's fine. I'm not going to put you on child support. I'm not, and she would come and she would pick up the children from school. Essentially, we worked it out between ourselves. That worked great for close to 7-8 years. At no time did I sit up there and go after child support. It was my intent to go to law school. Had this bill been in place at the time, I could have taken this bill and said, hey, it's now 8 years later. Let me go enroll in school real quick because guess what? I want those extra, monies for child support. And as long as I'm in school before I apply for child support, I can get it. And there has to be a time limit. 15 years? The child isn't 18 yet. There has to be a time limit. Senators, I came before you today, with regard to this House bill because it's really troublesome to me because I have 2 daughters. It's my intent for them to go to college, to get an excellent education, to get excellent jobs, in their futures. As I said before, our society is turning to the point to where more and more fathers it's acceptable for them to take care of the children while their spouse works, and vice versa. So more and more mothers are becoming the ones who pay child support, just like in my case. And granted, I have 2 girls, so I'm very overly protective. And I'm hoping this never comes up. Hopefully they never get divorced. But our statistics in our society are that divorce is very probable when 2 people get married.
Yes, well, thank you for your testimony, sir. We do have a question from Senator Claytor.
Thank you, Mr. Chairman. Appreciate the materials that y'all supplied us on this. What I'm trying to figure out is I don't do this type of work. I swore off of it a long time ago. And
I can
kudos to the people that do it and can
And they get very wealthy,
through
sir.
it. Huh?
They get very wealthy.
Well, there's a lot of work that needs to be done, and it's a difficult situation. Nobody's ever seems to be happy with the way it turns out. At any rate, if I understood your argument, I was looking at the language and what they were putting in there, and I was trying to wonder why they couldn't do already what they're saying. And you're saying in your note that there's Fourth Circuit law on it that says you can't do this. And I've looked at that, and that's the only case that you found on the issue. Is that correct?
Yes, Senator Claytor. Like I said, there's a paucity in our case law. It hasn't been addressed since 1998. It's been controlling authority.
All right. Just because that's the only decision you found on it, again, I don't do this work. Are you aware of whether the courts are doing this anyway already?
I'm sorry?
Are you aware of any instances where the courts are doing this already anyway? Have you seen any decisions? I know you all have a network out there where you talk to one another. Or any courts doing this type of child support order, figuring net child care costs as suggested in the bill already?
The answer is, Senator Claytor, because I attend a lot of court cases, and I do research and files on court cases. And the reason they do some of that, but it is because the other parent who is getting the custody of the children is already enrolled in school, and so they let her finish her schooling out.
Okay,
That's
well,
why they do
that's what
that.
paragraph A says, that if I'm reading it right, the parent has been in school for a period of time prior to the child support being established.
That's right.
It seems like a really big issue. You're here, and I'm trying to figure out if they're doing it in practice or not, and I'm wondering whether or not the Law Institute or any other body has weighed in on this issue at all.
I attend a lot of those meetings also, so I can tell you they have not, no.
Okay. I'll have some questions for Mr. Hazel at the appropriate time on that. Thank you.
I wanted to make one other comment, sir. There was going to be another individual here. He's supposed to send you an email, Senator Nevers, Thomas Pounds. He's one of your constituents. And he, too, is a domiciliary parent. So you have domiciliary parents and the grandfather and the father of a domiciliary parent that is fighting against this bill that supposedly the representative is passing for domiciliary parents. That should open a few eyes.
Okay, thank you, sir. We do have another question. Senator Murray.
Thank you, Mr. Chairman. The question I wanted to ask, Senator Claytor asked about the Law Institute looking at this issue, and you said you've been in some meetings. That you said, have they brought it up at all? They have not?
I've never seen it, and I went to quite a few of the children's support meetings. Remember when they had the child support with the young lady who's the judge now? You know, I'm getting older, Senator Murray. I can't remember all of these names. They had those child support meetings a few years ago, a couple of years ago. Jim Mitchell, one of our members, participated on that committee. And as far as I know, they did not bring anything like this up. As far as something that happens after, down the road, 6, 7, 8 years down the road. And like I said, it's already in the law.
So let me ask you a
But you can
question.
do it ahead
Senator
of time.
Claytor spoke to you. You all said that paragraph A on line 17 and 18 on page 1, you said some courts have been doing this already. If the parent had already been in school prior to the time of child support being established?
Prior to the divorce, yes.
Okay. So go ahead. I'm sorry. You were trying to say something.
Senator, I would posture that under that being considered under the spousal support.
Okay.
Because under spousal support there is
That's
a
right.
section.
Right.
But it's not postured as
In
an
the child
extra
support
order.
section.
Absolutely.
Okay.
Yes.
Right.
That's it, Mr. Chairman.
Okay, thank you, Senator Murray. Senator Claytor for another question?
But I'd like to ask my question of Representative Hazel. if I
Okay,
could.
he gets back, we'll get to you. Thank you. Thank you, gentlemen.
Thank you, Senators. I appreciate your time.
Okay, Representative Hazel. Okay, Senator Clater has a question before you close. Representative Hazel.
Thank you, Mr. Chairman. Representative Hazel, as I noted earlier, I don't do this work, so I'm trying to figure out where is this coming from. So where is this coming from, and why do we need it?
Thank you. That's a great question. I'm a former prosecutor, so when I got elected to the House, I've flipped sides, and I do criminal defense work, so I don't do this work. I was approached by practitioners that do family law. So I was approached 2 years ago, and I submitted this through Jessica Braun, who is who was then the attorney for the House Civil Law Committee, to the Law Institute. She's now the executive counsel to the Speaker, and apparently they didn't take any action. And so what she suggested is that I file the bill, and basically as stating that as we evolve as society, that the law should kind of evolve as well, and it doesn't really all the expansion. It covers the job training and employment right now. It just goes to a job search or the further education. And of course there is a trigger. Representative Hunter Green does primarily domestic work, and so that was his amendment to, and I think it made it a better bill, which actually put two triggers. It's either or. It's A, that they have to have been in school prior to the establishment of the child support, and the second one is they can't basically sustain. So, and, in order to improve their plight, as it would be, that would be B.
And I understand that where the parent has been in school for a period of time prior to the child support being established. I don't know that there's any causal related time to it. Where my wife was in cosmetology school before we got married, but had been a hairdresser for 15 years. I mean, where's the connection on that? And where's the connection that actually makes it be in the field where they were beforehand? And so I'm just trying to figure out where we're going with this and why do we need it. The gentleman that spoke certainly had some strong feelings about it and where it took us, and would like to hear from somebody that, no offense, knows more about it than you and I on the issue. So, thank you, Mr. Chairman.
But also, Senator Clater, that all this does is to make it the discretion of the court. It doesn't say that the court shall do it. It just gives them that opportunity to utilize it if the court deems it necessary. And of course, it's going to be with court involvement, so it's not some magical thing that someone can come craft and ram it down the other party's throats, as it may be.
Well, and I appreciate that, and it seems like the court is brilliant when they come down on your side and not so brilliant when they come down on the other side. So it's, there's always, sometimes the public and the participants lose sight of the fact that the court's trying to do the best they can. And in this field, whether people feel this way or not, there seem to be winners and losers that walk out of there, even though I believe the court does their best job to try to be fair as they can across the board. The way the participants feel is not always that. So I hear you. Thank you.
Thank you, Senator Clater. Senator Murray.
Thank you, Mr. Chairman. I don't do as much of this work as I used to do, but I do know that a lot of time and attention goes into establishing the child support guidelines and all those kinds of things. And I just and we kind of update them every so many years. The child support, was it 4 years? I forget. Yeah, every so many years. And I really think that this might be more appropriate. I know you said, I don't know if you did a formal resolution to ask the Law Institute to study this issue. I know that I would feel much more comfortable if the Law Institute would look at this with the Family Law section, Family Law Committee, and look at this in context with everything else that's going before we were asked to make a decision. It's the first year of this term. I'm sure if we asked them, they would get something back to us.
Well, Senator Murray, that's why I had submitted it to the Law Institute to begin with, not, 2 years ago, which they took no action. So I don't have a dog in the fight. I do criminal defense work. I'm happily married. I could see your concern, but
my only point is that this stuff is all supposed to kind of work together, and it gives me some pause that we would put this in the child support section of the law rather than on the spousal support or something like that, because when you start putting this in the child support section, the guidelines already contemplate the parent's income and the portions of parent's income for child support, and then you can also, and I don't want to go through the whole list of things, but you can also, if you're paying child support, you also can be compelled to pay for educational expenses for the child, tutoring, extracurricular activities. There's a whole bunch of things that's already outlined on that side. And I just think that these folks who do this stuff a whole bunch more than I do, if they looked at it and made a recommendation back, it'd make me a lot more comfortable. And I'm not comfortable enough to vote for this today, because I just think that we ought to look at it in context with the other child support provisions. That's it, Mr. Chairman.
Thank you, Senator Murray. Senator Clater for a question.
What does no action mean by these guys? You asked them to do something and they just never got back with you?
I'd have to ask Jessica, because Jessica Braun actually had submitted it on my behalf.
Okay, thank you.
Okay, thank you, Senator Clater. But the board is clear, and Representative Hazel, you have the right to close.
Mr. Chairman, I would simply submit it as is and ask for favorable passage.
Okay, thank you, Senator Murray.
Mr. Chairman, I guess so we can find out what taking no action means. Could we defer this a week and ask our staff to talk to the Law Institute to see if they took it up, and no action may mean that they looked at it and didn't think it was worthwhile. No action could mean they never looked at it until we could find out. Could we just defer it for a week?
Sure. The committee with 4 votes can do just about anything. So Senator Murray moves that we defer House Bill 872 for a week and see if we can find some resolution to these issues. Is there any objection to that? Hearing no objection, it will be deferred for a week, and we'll try to be back in contact with you, Representative Hazel.
Senator Murray, would that mean would the committee staff, would they contact the Law Institute?
Yes.
Oh, okay.
Mm-hmm.
Okay, thank you, sir, and we'll try to have the committee staff back in touch with you, let you know what they find.
Chairman Nevers and members. I appreciate y'all very much.
Okay, we have Senator Martini, Senate Bill 519.